Welcome to this annual Human Rights Lecture of the Master in Human Rights program at the Institute for Human Ecology. I invite anybody who's not familiar with the program to go to our website, which is easy to remember, mahumanrights.com, and you can learn more about the program. We have an info session on it on October, Suzanne, what's the date? October 25th. You can get that information through the website. Today, we're going to have our 6th annual Human Rights Lecture. It's the major event of the Human Rights Program each year. Previous speakers were Robert George of Princeton University, Chen Guangchen, the Distinguished Fellow in Human Rights here at Catholic University, the commissioners of the U.S. Commission on Unalienable Rights, which anybody who hasn't read it, I commend that report to you, Ambassador Sam Brownback, and last year, Father Kevin Flannery of the Gregorian University. Before I say a word about the speaker, I just want to say a word about the subject. The push for for assisted suicide as a human right, or as some kind of right that should be created, is long-standing in the West. There's been a sustained push in the United States and around the world. But in 1997, the U.S. Supreme Court held that it is not a constitutional right. Assisted suicide is not a constitutional right in Glucksberg v. Washington. And just parentheses, it adopted a test for implying whether there is a constitutional right, a test which was just affirmed in the Dobbs case and which replaced the untethered test of Planned Parenthood v. Casey of an idea of liberty that really has no boundaries. So now the test from Glucksberg has actually become the test. But in any case, Glucksberg was very important, but as we all know as Americans, all that means is the issue has gone to the states, and many states, unfortunately, and a growing number of states, unfortunately, including the District of Columbia, have found various ways to find assisted suicide as a protected right. Now, the pressure builds around the world and it builds overseas. And the question before us, and believe you me, when you look at spiraling healthcare costs, an aging population, and not enough young people to pay those costs, assisted suicide is the issue that is going to be in our laps before we know it. So to reflect on this question about whether there is a human right to assisted suicide, we'll hear tonight from Professor John Keown. Professor Keown, I believe, began his academic work studying the developments in the Netherlands, which was the first Western country to recognize this right in various ways. He is the Rose Kennedy Professor of Christian Ethics in the Kennedy Institute of Ethics at Georgetown. He graduated in law from Cambridge University and took a doctorate in law at Oxford University, after which he was called to the bar of England and Wales, which means he became a lawyer of the Middle Temple. After teaching medical and criminal law at the University of Leicester, he became the first holder of a lectureship in law and ethics of medicine at Cambridge University, where he was elected to a fellowship in Queen's College, and later a senior research fellowship at Churchill College. In 2015, he was made a Doctor of Civil Law by the University of Oxford in recognition of his contribution to law and bioethics, a doctorate that is rarely given and is highly esteemed. I would say one other distinction he has, which I don't want to forget, is that he joins some other lecturers in our human rights series as being a member of the advisory board for my human rights program. His second and heavily edited revised version of his book, Euthanasia Ethics and Public Policy, an Argument Against Legalization, I think about 1,000 pages, each of which I read and edited. I'm acknowledged in the intro, but I can tell you it's a good book because I've read every word of it. Anyway, it was published by Cambridge University Press in 2018. His research has been cited by distinguished bodies, including the U.S. Supreme Court, the Law Lords, the House of Commons, the House of Lords Select Committee on Medical Ethics, and the Australian Senate. In my opinion, he is the world's leading expert on this subject. I'm very happy to have him with us tonight, Professor Keown.
Well, thanks very much, Bill, for that very kind introduction. And thank you to you and your centre for inviting me to give this very prestigious lecture, especially in the light of so many eminent predecessors who have delivered it. So it's a great honour, and I'm very grateful. Always great to be back here at CUA, wonderful campus, wonderful people. And tonight, I think I may be speaking to partly specialist, partly general audience. So I've decided to pitch the talk at a level accessible to the layperson, so it won't be very technical. And you'll see the title of the talk there. Right, there we go. There's a little outline of the talk. And I'll be suggesting there were at least three major flaws in the case made for the legalization of physician-assisted suicide for the terminally ill. Those are the three flaws. We'll go through them in greater detail shortly. And then I'll briefly mention some additional flaws and a few conclusions. So I won't speak more than, say, 40 minutes, and that'll leave time for Q&A. I feel like Frank Sinatra with this. Johnny Bennett. I don't see a bullet. Okay, are we ready? Ready to roll? So let me start by quoting a distinguished judge, or rather first, Father Anthony always likes me to tell a joke before I start giving a talk. So I have a really bad one for you. It's this dog back in the Wild West, Tombstone. And there are these men in this saloon, you know, it's all a bit rough and there's a lot of drinking and swearing, sort of, sorry, Father, but this is the real world, and swearing. And suddenly the back wing doors open and a huge dog comes into the saloon with blood pouring from its front leg. Everyone turns round in silence and looks at the dog, and the dog suddenly says, "I'm looking for the man who shot my paw." Was that good? Was that right? So the distinguished jurist, Lord Judge, the aptly named former Lord Chief Justice of England and Wales, has described physician-assisted suicide as the great moral and legal problem of our times. So as Bill said, this is a major moral and legal issue, particularly in the developed world. Now, parliamentary debates, or any debate, any legislative debate about its legalisation should therefore be of a commensurately high quality. And over around 30 years, the UK Parliament, mainly the upper chamber, the House of Lords, has considered a series of bills based on the kind of Oregon model to permit physician-assisted suicide for the terminally ill. And the quality of the debates, and of two select committees they appointed, has been high. What then of the most recent bill, which was introduced by Baroness Meacher, in which no fewer than 130 members of the House of Lords spoke on one day? That illustrates the continuing importance of this issue. Now, her particular bill fell because of lack of parliamentary time, but the debate merits analysis, partly because of the profound moral importance of the issue, but also because it's not going away. There'll be future bills introduced there and in the US states around the country. At the moment also, the House of Commons has set up a committee which is gathering evidence on the issue. There's a bill, an Oregon-style bill, about to be introduced in the Scottish Parliament, and the Irish Parliament has also set up a committee which is currently listening to evidence, and both the English and Irish committees, you can access their websites online and listen to the testimony that's being given by the various witnesses. So it's very much a topical and timely issue. Well, what lessons can parliamentarians learn from the latest debate on the bill introduced by Baroness Meacher? I'd like to suggest that the argument she advanced, and that is advanced typically around the world in support of these sorts of bills, was flawed in at least three main respects. The first is that her claim was that the bill's purpose was to prevent suffering, but interestingly, her bill did not require that patients be suffering and excluded many patients who are suffering. Secondly, it was asserted by her supporters that by decriminalising suicide, the Suicide Act 1961 condones suicide, and that therefore the continuing prohibition on assisting suicide is illogical. And thirdly, principled arguments in favour of her bill were strikingly superficial. In particular, the principle of respect for autonomy was exaggerated and at the expense of the principle of the sanctity of life, and the obvious implications of getting that wrong were ignored. Now, interestingly, no fewer than 4 highly eminent judges participated in the debate. So they were retired judges, and they all supported Baroness Meacher's bill. One would have expected their contributions to have been of a very high calibre, particularly in relation to matters of law and legal principle. But as if to underline the disappointing quality of the debate, I will draw upon the speeches of these 4 judges to illustrate the above 3 flaws. So let's turn firstly to the first flaw, which was mischaracterising the scope of the bill. So the bill would, said Baroness Meacher, afford terminally ill, mentally competent people over 18 the right to choose the timing and manner of their death. 2 independent doctors would have to approve the application, certifying that the patient's life expectancy was no more than 6 months. The application would also require the endorsement of a High Court judge, so that's a safeguard that is not in the Oregon-style law. She said she feared being one of the unlucky small minority of people who suffer a traumatic dying process in which our precious palliative care services cannot relieve our suffering and cannot enable us to have a dignified death. What she called her truly modest bill was based on tried and tested laws from overseas, not least Oregon, and its sole aim was to reduce unnecessary and unbearable suffering. Patient choice, she said, meant nothing unless it included the right to decide when one could take no more suffering. Now, all this was confusing. Why? Well, her bill didn't require that the patient be suffering at all, or would be likely to suffer, let alone unbearably. Nor did it require that patients who were suffering had consulted a palliative care physician, let alone tried palliative treatment. The bill merely required that the patient have a terminal illness. So it was just like the Oregon-style law. So patients would fall within her bill if they had a terminal illness, and there's a big question mark about precisely what terminal illness means, but were not suffering at all. Conversely, patients who had a chronic but non-terminal illness that caused intense and protracted suffering fell outside her bill. Neither she nor her supporters, including the 4 eminent judges, explained why her bill excluded the following 3 groups of suffering patients. 1, those who are not terminally ill and who face many years of suffering, maybe from chronic arthritis. 2, those who are suffering intensely but who are physically unable to kill themselves, even if given a lethal prescription. and who therefore wanted a lethal injection, that is euthanasia. And 3, suffering patients who lacked legal capacity to request assistance, such as disabled infants or patients with advanced dementia. None of those 3 categories were included in her bill. Now, clearly, if the 2 main moral arguments for bills like hers and bills like Oregon's are respect for patient choice, autonomy, and the duty to alleviate suffering, beneficence, those same principles justified physician-assisted suicide for the chronically ill. They also justified voluntary euthanasia, especially, but not only, for those who are physically unable to kill themselves, even with assistance. And if autonomy and beneficence are thought in combination to justify voluntary euthanasia, then beneficence alone justifies non-voluntary euthanasia to end the suffering of patients lacking capacity. Why? Well, the absence of autonomy does not cancel the duty of beneficence. If a doctor has a duty to alleviate suffering, that applies to patients who cannot request a lethal injection. So the failure of supporters of the bill to follow the obvious logic of where the principles informing the bill led was one of the most striking omissions in their speeches. Another problem with the arguments in favour of the bill were that its supporters hoped that people wouldn't refer to the experience in other jurisdictions. Baroness Meacher said, we don't really want to bring in the Netherlands, Belgium, or elsewhere, because she thought they were irrelevant. But why irrelevant? It's true that the Dutch and Belgian laws, and the law in Canada, allows not only physician-assisted suicide, but also euthanasia, and apply to those who are not terminally ill. Well, that illustrates, does it not, the total arbitrariness of bills limited to physician-assisted suicide and to the terminally ill. What of the Oregon Death with Dignity Act? Was it, as she suggested, tried and tested? Well, if you want really to start some research into that act and its operation, I can recommend 2 very good sources. One is a classic volume on physician-assisted suicide and euthanasia, written by Dr. Neil Gorsuch, who is now, of course, a justice of the US Supreme Court. I'll be referring to his book later. And Professor Alex Capron, probably the country's leading expert on health law and ethics, whose analysis of the Oregon law said its safeguards are largely illusory. Their illusory nature has not, however, prevented supporters of so-called assisted dying, a dreadful euphemism, from suggesting their relaxation on the ground that these supposed safeguards are burdensome obstacles, precisely because they exclude patients who are not terminally ill, patients who cannot self-administer death, mature minors, and requests made in advance by those who later develop advanced dementia. So that then is the first flaw in the case made for the bill. The second flaw, which I'd like to mention, is the mischaracterization of the decriminalization of suicide. Is that? Yeah, yes, then. So the debates, and this is very common in debates about physician-assisted suicide, the supporters of the bill misunderstood why suicide was decriminalized in England and elsewhere. So in England, it was decriminalized in 1961 by the Suicide Act, which maintained the prohibition on assisting or encouraging suicide, which is still in force today. And supporters of the bill said, well, suicide is no longer a crime, so it's illogical that assisting suicide is still a crime. If people have got a right to commit suicide, how can the law sensibly prohibit assisting them to commit suicide? Now, this is a fundamentally flawed argument because, as the history of the 1961 Act demonstrates, suicide was not decriminalized to condone suicide. It was decriminalized for other reasons, including the enlightened understanding that a more humane and promising way of dealing with the social problem of suicide was by treating its causes, particularly mental illness, rather than by subjecting those who attempted suicide to the criminal process. Responding to concerns at the time that decriminalisation might be perceived as condonation, the government minister responsible for steering the bill through Parliament made it clear this was not the government's intention. He said, because we have taken the view, as Parliament and the government have taken, that the treatment of people who attempt to commit suicide should no longer be through the criminal courts, it in no way lessens, nor should it lessen, the respect for the sanctity of human life which we all share. It must not be thought that because we are changing the method of treatment for those unfortunate people, we seek to depreciate the gravity of the action of anyone who tries to commit suicide. And he went on, I should like to state as solemnly as I can that that is certainly not the view of the government, that we wish to give no encouragement whatever to suicide. I hope that nothing I have said will give the impression that the act of self-murder or self-destruction is regarded at all lightly by the government. So it was clear what the legislative intent was. It was not to condone suicide. And in a later leading case, the case of Diane Pretty, this was reinforced by the senior law lord, Lord Bingham. In that case, he said, the law confers no right to commit suicide. Suicide was always, as a crime, anomalous, since it was the only crime with which the defendant could ever be charged. The main effect of the criminalisation was to penalise those who attempted to take their own lives and failed, and secondary parties. Suicide itself, and with attempted suicide, was decriminalised because recognition of the common law offence was not thought to act as a deterrent, because it cast an unwarranted stigma on innocent members of the suicide's family, and because it led to the distasteful result that patients recovering hospital from a failed suicide attempt were prosecuted, in effect, for their lack of success. Lord Bingham concluded, while the 1961 Act abrogated the rule of law whereby it was a crime for a person to commit or attempt to commit suicide, it conferred no right on anyone to do so. Had that been its object, there would have been no justification for penalising by a potentially very long term of imprisonment, 14 years, one who aided, abetted, counselled or procured the exercise or attempted exercise by another of that right. The policy of the law, he said, remained firmly adverse to suicide, as that penalty makes clear. So one might have expected in the debate on the Meacher Bill that at least one of those four former judges would have made it clear to the House of Lords, one, that decriminalisation was not intended to condone suicide, let alone establish a right to suicide. Two, that suicide, while no longer a crime, remained contrary to the policy of the law, as Lord Bingham pointed out in the Pretty case. And three, that this was why the Suicide Act maintained the criminal prohibition on assistance or encouragement. But none of the four judges did so. On the contrary, one of them said suicide was accepted as a lawful right in the interests of dignity and so forth by the Suicide Act 1961. And therefore it was illogical to deny those with the very lowest quality of life and the strongest justification for wanting to accelerate death the power to achieve it. So we had a senior former judge saying the Suicide Act did really create a right to commit suicide. Another of the four judges said, as suicide is no longer a crime, I suggest it defies logic to preclude a patient with appropriate safeguards from seeking assistance to terminate his or her life. A third of the judges asked, if a person may choose freely to commit suicide, what justifies a refusal to allow them to obtain willing assistance? Not only is the belief that by decriminalising suicide, Parliament intended to condone it mistaken, seriously mistaken, but it paves the way to another, no less mistaken belief. This is that the prohibition on assisting suicide that remains can only be justified as a way of protecting the vulnerable from being unduly influenced to request assistance in suicide, and that the central question for consideration in the legalisation debate is therefore whether the blanket prohibition is overbroad to achieve that purpose. Couldn't we legalize suicide for those who are not vulnerable and maybe maintain the prohibition for those who are? It was this erroneous belief, among others, that led the Supreme Court of Canada egregiously to invent a right to voluntary euthanasia and physician suicide in 2015. The true legal position is that the blanket prohibition on assisting suicide is no more designed to protect only the vulnerable than the blanket prohibition on murder. Both criminal prohibitions aim to protect everyone, whether vulnerable or not, and whether or not they want autonomously to be assisted in suicide or to be killed. So that then was the second flaw in the debate. So on to number 3. Thanks, Ed. And now the superficiality of the ethical argument in favour of the Oregon-style bill, or Oregon-style plus approval by a High Court judge. The way in which supporters exaggerated respect for autonomy and, if you like, denigrated the principle of the sanctity of life. Now, many of those who spoke in favour of the bill claimed, often drawing on personal stories of distressing deaths, as advocates of physician-assisted suicide often do, that it was needed to prevent people from dying in agony. Anecdote is not, however, argument. Distressing deaths, while a matter of the utmost importance, not least to those who suffer them and to their loved ones, are by themselves no more an argument for legalising physician-assisted suicide than for improving palliative care services. And although the UK in particular is a world leader in palliative care, it remains, quite indefensibly, unavailable to many, many patients. Why was the solution to distressing deaths so widely and readily assumed to be helping suffering patients to kill themselves, rather than providing adequate resources to ensure the palliation of their suffering? Moreover, as we'll see later, the evidence from states like Oregon concerning the reasons why people seek physician-assisted suicide shows that inadequate pain control is actually one of the least common reasons that they give, way behind losing autonomy and being less able to engage in activities making life enjoyable. So members of the Lords and those watching the Meacher debate would reasonably have expected the speeches by the 4 judges in particular to have demonstrated an impressive command of the key legal and ethical principles in play, but their speeches actually reflected rather than rose above the average, the disappointing average, not least by exaggerating the principle of autonomy and ignoring the principle of the sanctity of life. The case advanced for legalization reflected the assumption that respect for autonomy was if not the paramount moral principle. For one of the eminent judges, the bill rested on the principle of personal autonomy, which he said was an inseparable aspect of human dignity, which has been at the heart of the Western concept of human rights since the UN Declaration of Human Rights in 1948. That judge pointed out that a competent person who had not been unduly influenced had an absolute right at common law to insist on the withdrawal of treatment. Another judge went so far as to assert, there are many important human rights, but in the end, they can all be encapsulated in a single overriding right, the right to personal autonomy. I think that sentence is worth repeating. This judge was a former president of the UK Supreme Court. There are many important human rights, but in the end, they can all be encapsulated in a single overriding right, the right to personal autonomy. He too thought that the case for the bill was supported by the legal right to refuse treatment. Now, it seems to me that those kinds of arguments suggest a failure to appreciate first the proper limits on respect for autonomy, the logical implications of attaching an exaggerated importance to autonomy, and the questionable relevance of the case for physician-assisted suicide, of the right to refuse treatment. So I'll say a little about each of those three concerns. Autonomy is not a moral absolute. It has limits. In fact, the basis of the rights enumerated in the UN Declaration is not autonomy, but, as its preamble affirms, dignity. Indeed, the Declaration nowhere mentions a right to autonomy. While respect for autonomy is an important moral principle and an aspect of human dignity, it requires careful definition and application. Also, autonomy may be trumped by other principles, as well as by human dignity, whether one's own or another's. It's right, for example, to prohibit an autonomous choice to sell another person into slavery, even with that person's consent. Or an autonomous choice to sell oneself into slavery. Such choices are radically inconsistent with human dignity. Indeed, what is the criminal law but an extensive web of restrictions on our choices, however autonomous? Many of the criminal law's restrictions seek to prevent harm to other people, but some aim to protect us from harming ourselves. It's, for example, a crime to drive a car without a seatbelt in many jurisdictions. It's an offence to cause actual bodily harm, even with the victim's consent, absent a limited number of justifications accepted by the courts, let alone to kill them with their consent. In short, simply to invoke personal autonomy as a justification for the abolition of the historic criminal prohibition on physician-assisted suicide is simply to beg the question. The criminal law has always rejected the victim's request or consent as a defence to the charge. Secondly, what about the logical implications of exaggerating the importance of autonomy? So although a number of the judges appeared to attach paramount significance to autonomy, they didn't follow through the logic of so doing. One of the judges, the one who claimed autonomy was the paramount overriding moral principle, said personal autonomy has no more important aspect than the right to control your very existence. It is your life to deal with as you see fit. If you want to end your life, you are entitled to do so. And if you have a fundamental right to end your life, you must require very powerful reasons why you should be denied assistance if you need to exercise that right and cannot do it without assistance. But as we have seen, the bill he was supporting limited the exercise of this supposed right to control your very existence to the terminally ill and to the method of ingesting lethal drugs obtained on prescription. Why deny hastened death to autonomous people who are not terminally ill, or who were, perhaps because of total paralysis, unable to take their lives even with assistance? That judge suggested in one of the cases in which he sat, one of the important leading cases, that in law and morality, a satisfactory boundary between euthanasia, lethal injections, and assisted suicide could be found in personal autonomy. In assisted suicide, he said, the patient had not been killed by anyone and had ended their own life pursuant to a voluntary and settled intention. But his lordship appeared to confuse autonomy with agency. A death by lethal injection may respect autonomy just as much as a death by taking drugs prescribed by a doctor. Not least because, in the latter case, there need be no doctor present to check that you are still autonomous when you take the drugs. And that's one of the criticisms that Professor Keown had of the Oregon law. The doctor needn't be present when you take the maybe months after he or she prescribed them. And a law that denies lethal injections clearly frustrates the autonomy of those who want them. And they are likely to be many more than those who want a lethal prescription. The overwhelming majority of cases of assisted dying in Canada and the Netherlands involve lethal injections. In Canada in 2021, virtually all the 10,000 cases of so-called assisted dying involved euthanasia. Only 7 were cases of physician-assisted suicide. Similarly, in the Netherlands, only 2.5% of cases that year involved physician-assisted suicide. A brief word about the third criticism I've got of this argument in favour of the bill, namely the invocation of the relevance of refusing treatment, the right to refuse treatment, and physician-assisted suicide. So at least two of the judges that we mentioned pointed out, oh, well, patients have got an absolute right to refuse treatment. So if you, this means that if you're on a ventilator, you can kill yourself by refusing treatment. The doctor disconnects the ventilator. That's assisted suicide. So if the law accepts that, it should also accept the doctor writing a lethal prescription for you. Well, there are a number of problems with this analogy between physician-assisted suicide and the right to refuse treatment. First, the claim that there is an absolute right to refuse treatment is actually more controversial than many judges and scholars and practicing lawyers appreciate. So, for example, in England, the mental health legislation allows treatment to be given to patients even if they're competent and even if they refuse it. Second, even if the right to refuse treatment were absolute, its relevance to the arguments for physician-assisted suicide would not be obvious. Bill mentioned the Glucksberg case, in which the US Supreme Court held there is no constitutional right to physician-assisted suicide, and the companion case, Vacu and Quill, really grappled with this argument. The appellates in that case were saying, well, yeah, patients have a right to refuse treatment. Their doctor must comply with that. That's physician-assisted suicide. So the law should allow the doctor to prescribe lethal drugs for those who are not dependent on ventilators. Well, the US Supreme Court rejected that argument, and I think rightly so. Chief Justice Rehnquist, in his judgment, rightly noted an important distinction. In the case of withdrawal of treatment, the doctor need not be intending to assist the patient's death, even if the patient, by requesting disconnection, is motivated by a suicidal intent, and that needn't be the case, but even if they aren't, the doctor, in respecting that refusal, need not be motivated by an intent to assist the patient's suicide. Whereas if you write a prescription of lethal drugs, that's precisely what you're intending to do. And a third question would be, well, if a competent patient does have an absolute right to refuse treatment, and if that is a good argument for physician-assisted suicide, why isn't there an absolute right to physician-assisted suicide? Why should it be limited to the terminally ill? One of the judges commented on withdrawal of treatment cases from incapacitated patients and said, well, we've already made decisions allowing withdrawal of treatment from incapacitated individuals. Many withdrawal of treatment of cases, such as the famous Tony Bland case, which involved withdrawal of tube feeding from a young man who was in a persistent vegetative state, and the conjoined twins case, you may remember in the year 2000, very challenging case where the courts had to decide whether to separate the two twins, Jodie and Mary, when the weaker twin, Mary, would die as a result of the separation. The judge says, well, we've made those cases. And I suggest, he said, there's an obvious flaw in logic and consistency in making such early termination of life possible for incapacitated people, but not permitting a person of full capacity, free from undue influence and properly informed, to request assistance in dying. Well, again, here, these comparisons are problematic. Withdrawing treatment from an incapacitated patient, again, need involve no intention at all to hasten their death. The intention could be to withdraw a treatment which has become futile, or treatment, if not futile, that is excessively burdensome to the patient. So it's problematic even to categorize such cases involving termination of life as opposed to termination of treatment. Also, if that judge thought cases like Tony Bland and the conjoined twins case did involve the intentional termination of life of the incapacitated, and if he thought they're relevant to the case for physician-assisted suicide, well, why don't those precedents also support lethal injections for incapacitated patients? So It was odd that the judges seemed to assume that the prohibition on physician-assisted suicide was an unjustified breach of respect for autonomy. It was no less odd that they did not question the significant limits placed on autonomy by the very bill they were supporting. Odder still for it to be suggested that cases like Bland and the conjoined twins case and the right to refuse treatment were arguments in favour of physician-assisted suicide. It was even more noteworthy that none of these judges even mentioned a relevant and indeed fundamental legal principle to which we shall now turn, the sanctity of life, a principle whose importance was actually reaffirmed in both the Tony Bland case and the conjoined twins case. Now, this principle of the sanctity, or as I prefer to call it, the inviolability of life, is of foundational importance to law. The principle does not, it's important to say, require the preservation of life at all costs. That is sheer vitalism. That's a caricature of the principle. At the heart of the inviolability principle is an opposition to intentionally killing the innocent or assisting them to kill themselves. And that principle has long shaped Anglo-American criminal law. A main reason the US Supreme Court rejected the argument for a constitutional right to physician-assisted suicide was that Anglo-American common law had either punished or otherwise disapproved of both suicide and assisting suicide for over 700 years. In the Tony Bland case, one eminent judge said the fundamental principle in this case is the principle of the sanctity of life, a principle long recognized not only in our own society, but also in most, if not all, civilized societies throughout the modern world, as is indeed evidenced by its recognition both in Article 2 of the European Convention for the Protection of Human Rights and Fundamental Freedoms and in Article 6 of the International Covenant of Civil and Political Rights. The core of this foundational principle was neatly captured in an impressive report produced by a House of Lords committee in 1994, the Select Committee on Medical Ethics. This very eminent committee considered the arguments for legalizing euthanasia and physician-assisted suicide and unanimously rejected them. Its report observed that the law's prohibition on intentional killing was, quote, the cornerstone of law and of social relationships that protects each one of us impartially, embodying the belief that all are equal. And the presiding judge in the conjoined twins case quoted that statement and added, what the sanctity of life doctrine compels me to accept is that each life has inherent value in itself, and the right to life, being universal, is equal for all of us. In one case, a mother appealed against her conviction for murdering her adult son, Thomas, who was in a persistent vegetative state following an accident. Lord Judge, the Lord Chief Justice, observed that in the eyes of the law against intentional killing, a disabled life, even a life lived at the extremes of disability, is not one jot less precious than the life of an able-bodied person. It's this understanding of radical human equality that the principle of the sanctity or inviolability of life upholds. The lives of all patients, however disabled, are of equal intrinsic worth and merit protection. The value of Thomas's life lay not in his autonomy, for he no longer had any, nor in his or anyone else's valuation of his life, but in his intrinsic dignity as a member of the human family, a fundamental worth he retained despite his profound intellectual disability. It's often said it's a golden thread of English criminal law that it is for the prosecution to prove the defendant's guilt beyond all reasonable doubt. Well, I think the principle of the inviolability of life could reasonably be described as a golden chain of English criminal law. A law that were to allow certain people to be killed or helped kill themselves, whether on account of their illness or disability, would rupture that chain. And it's really remarkable that none of the four judges pointed out that the Meacher Bill was then anything but truly modest, a bill that would have ruptured that fundamental legal and moral principle. None of the 4 judges adverted to the profound implications, moreover, of rejecting the inviolability of life. In particular, that the law would inevitably move into a discriminatory moral world where some lives were arbitrarily judged worthwhile, but others not. The judges' focus on autonomy may well have distracted them and their listeners from the reality that laws permitting physician-assisted suicide and voluntary euthanasia do not merely permit certain private exercises of personal choice. For one thing, the decision that the patient should be helped to take their own life is not made by the patient. The bill required the patient's request to be approved by 2 physicians and by a judge. For another, the bill would embody the moral judgment that it's entirely reasonable for some people to put an end to their lives because death would benefit them, and it would benefit them precisely because their lives were no longer worth living. The bill didn't just to seek anyone a right to access physician-assisted suicide. It marked out conditions like terminal illness, which mark out a category of people who, it was thought, would be justified in seeking a hastened death. So legalizing so-called assisted dying instantiates a moral judgment that some people, but not other people, would be justified in thinking themselves better off dead and in acting on that judgment and being helped to act on that judgment. Not only would the belief that certain lives were not worth living be contentious and erroneous for the law to adopt, but it could, and surely sooner or later would, be extended to many other patients, including the frail elderly and people with a range of disabilities. Such vulnerable folk would be the prime candidates to be thought of, as they already are, by many in a society that values youth, appearance, productivity, as leading lives that are, in the words of one of the 4 judges, pitiable and of low quality. That's how he described those who would be eligible under the bill he was supporting. So it was small wonder in the debate that leading members of the House of Lords representing people with disabilities spoke unanimously against the bill. And the judge who described those who would be eligible as leading lives that are of pitiable and of low quality was much closer to the mark than his judicial brethren, who focused on autonomy. Once this is appreciated, why should the law not extend its pity and compassion to embrace those who are not terminally ill but are nevertheless suffering, such as infants with physical or intellectual disabilities? As we noted earlier, the absence of autonomy does not cancel the duty of beneficence. Once the criminal law abandons its historic bright-line prohibition on intentionally killing the innocent, which, as the Select Committee on Medical Ethics said, guarantees everyone's right to life, everyone's equality and dignity, many more people than the competent and terminally ill would, sooner or later, come to be regarded as justified in thinking themselves better off dead. And if, as the former President of the Supreme Court sweepingly claimed, we'll remember his dramatic statement, all important human rights can be encapsulated in a single overriding right, the right to personal autonomy, where does this leave those many people who lack autonomy, such as those with profound intellectual disabilities? There's no shortage, as we know, of bioethicists and others who think that people lacking rationality and self-awareness are non-persons, mere biological organisms. The logical or conceptual slippery slope on which the law would set foot once it embraced the notion that certain people would be better off dead is not merely theoretical. Take the Netherlands. It is no accident that its euthanasia law is, unlike the Nietzsche Bill, limited neither to the terminally ill nor to physician-assisted suicide, nor that the Dutch courts, applying the principle of beneficence, slid effortlessly from endorsing lethal injections for competent patients in 1984, the Dutch Supreme Court held that in 1984, to condoning lethal injections for disabled infants in 1996, only 12 years later. Nor that the Dutch government proposed in 2016 the extension of assisted dying to the elderly who felt their life was completed. Nor that in 2020 it decided to permit euthanasia for children between the ages of 1 and 12. So a few concluding remarks. Some additional flaws. I'll just touch on, we've identified the three main flaws. I'll just briefly hint at one or two others that were made by some of the eminent judges who supported the bill. Firstly, there was a question about just whether the bill would only allow physician-assisted suicide or whether it would spill over into euthanasia, because it did allow the assisting health professional to assist in the self-administration of the lethal poison. So it's clear that sometimes assisted suicide and euthanasia can get very, very close indeed. The line is not always black and white. And it might be that that particular bill would have allowed some form of euthanasia. One of the eminent judges had further reasons for supporting the bill. I'll just throw out one or two of them because they're not uncommon. He said, well, rich people can travel abroad. They can fly to Switzerland. And in Switzerland, the law has never forbidden assisting suicide if the motive of the assister is not selfish. Well, that's true. Rich people can fly to Switzerland and access assisted suicide there. But rich people can fly to countries where hard drugs or child sex or female genital mutilation are available. Moreover, only 23 British people flew to Switzerland in 2021, so we're not talking about a flood. And some of those people have not been terminally ill. There was a young man called Daniel James. He was only 23 years old, and he was paralyzed from the chest down after a rugby accident, and he went to Switzerland and was assisted to kill himself. So if the judges think that the fact of people flying to Switzerland who are terminally ill is a good argument for allowing that in England, well, what about all those people flying there who are not terminally ill? One eminent judge said, well, the bill was also supported by the way we deal with suffering animals. We put down suffering animals. Well, we do, but that involves euthanasia, not physician-assisted suicide, and of the non-voluntary kind. Kitty or Rex or Fido doesn't ask for a lethal injection. And finally, another common argument that one of the judges echoed, it's very common, public opinion. The majority of opinion polls show that people support this. Well, yes, but we have to be very careful, don't we, with opinion polls. Partly because that people are asked about whether they support assisted dying, which is a very fuzzy euphemism. Indeed, in one poll in 2021, no fewer than 42% of respondents, when asked about assisted dying, thought it meant the right to refuse life-prolonging treatment. They didn't think it meant a lethal prescription. In any event, opinion polls are a poor guide to sound ethics. So, in conclusion, so far, happily, the British courts have, unlike the Canadian courts, properly declined to trespass on the legislature's right to decide whether or not to legalise physician-assisted suicide or euthanasia. And probably no legislative body in the world has debated this issue more thoroughly, especially over the last 25 or 30 years, than the House of Lords. And the overall quality of debates has been quite high until, sadly, the latest one, where I hope to have shown a number of significant flaws in the arguments for legalisation. So given that physician-assisted suicide is, as Lord Judge said, I mentioned at the beginning, the great moral and legal problem of our times, is to be hoped that future debates will not exhibit the same flaws. The stakes are too high. Thank you.
Thank you, John. Thank you very much. Okay, we'll open the floor for questions. and I'll step aside and let you handle them. So.
So you cited some arguments to draw a distinction between assisted suicide and withdrawal treatment. Now, I'm not a legal scholar, but I would like to offer a very simple argument, which is that by assisting somebody to commit suicide, you're actually committing an affirmative action that leads directly to the person's death. Whereas by withdrawing treatment, you just let the illness kill the patient. You don't kill the patient. Because if the two were equivalent, let's say I have an acquaintance who is engaging in self-destructive behavior, like doing hard drugs or perhaps weighing 400 pounds and eating 2 bags of cookies every day. So by my not removing food from them, am I assisting them to commit suicide? I guess not. That's my question. So what do you think?
Thank you. Well, in Vacu and Quill, the Supreme Court actually gave that argument as another reason for distinguishing physician-assisted suicide from withdrawal of treatment. The argument that you're not causing the patient's death, the underlying condition is causing the death. I'm not persuaded by that argument for the following reason. It seems to me that if you switch off someone's ventilation, you may well be causing their death, because if you don't switch off the ventilation, they'll go on living. So what is it that's causing them to die now rather than later? It's switching off the ventilator. And there's a good argument that that's not just an omission, that's actually an act that you're carrying out. So I think it's a problematic argument. It persuaded the Supreme Court. It doesn't really persuade me. And nor does it persuade, or did it persuade, Dr. Gorsuch in his book, which I'll mention in a second. He considers the argument and rejects it. But he nevertheless rests on the argument that intention is key here, that withdrawal of treatment need involve no intention, either on the part of the patient or on the part of the doctor, to hasten death, whereas physician-assisted suicide and euthanasia do. So I think that's a solid, irrefutable argument. The causation argument, I think, is a little trickier, is a little less persuasive. But thank you for that. While I'm up here with the little remote, I might, should I just say a brief word about some of the resources before we forget, because they're very good. So this is a paper I've shared, published by Policy Exchange, which is a leading think tank in the UK, about the Meacher Bill. And sure as eggs is eggs, there will be future bills coming through the House of Commons and the House of Lords, as there will be in state legislatures in those states that have not yet followed Oregon. That is a very handy little book called Debating Euthanasia. If you wanted just a very good snapshot of the current debate, that would be a good book to get. It's written by Professor Emily Jackson. She is a professor of law at the LSE in London, leading advocate of legalization. And we were each invited basically to write half of the book each. So she wrote her half, I wrote my half, and then they were stuck together without us seeing what the other was writing. So you've got arguments for and against. Later I did actually write a response to her part of the book, which is available in another edited collection. That'll be on my list of publications on my page on the Kennedy Institute. This is a collection of essays, clinical, legal, philosophical. The first 6 chapters are a ding-dong debate between John Harris, the British utilitarian, and John Finnis, the eminent natural law scholar, also containing a very good essay on theological aspects of euthanasia by now Archbishop Anthony Fisher. And then this is a classic book, the one I referred to by Dr. Gorsuch, now Justice Gorsuch, on the future of assisted suicide and euthanasia, has excellent chapters on the Glucksberg and Quill cases, and excellent chapters on autonomy, on the inviolability of life. It really is, I think, one of the best books ever written, if not the best book ever written on the subject. So I'd strongly recommend that. And then a far more inferior contribution to the literature is my own meagre offering here, Euthanasia, Ethics and Public Policy, second edition, published in 2018. So thanks for your patience while I went through those. I wanted to make sure you were aware of them. But any more questions?
Thank you very much. I found this really helpful. I do have a question about this one argument you made in a couple places, which says, in general, incompetence doesn't undermine a duty of beneficence. And so if we're going to say euthanasia is permissible in cases where there is consent, then where consent can't be had, the implication would seem to suggest it's also permissible. And I worry in lots of sort of parallel cases that reasoning doesn't, this sort of reply doesn't seem persuasive, right? So, it's permissible with consent to have sex with someone. It can be a nice thing to do for a spouse, for example, assuming they consent. That doesn't mean that in incompetence, this gift is then something that can be given absent consent. It is the case that there's certain types of relations and rights where consent becomes a necessary condition for the act to be an act of beneficence in the first place. Given that it seems quite possible for someone to adopt a similar principle here that says, look, goodness is always good for someone, something of this sort. And so because you can be a sort of privileged judge of what's good for you, this is a very common argument made by advocates of euthanasia and physician-assisted suicide. Consent is necessary because that's necessary for you to sort of incorporate your death as part of your good. Beneficence can only go forward assuming there's consent, and so you don't get this sort of extension of the principle. I was curious if you think, like, in principle, these sort of replies don't make sense, or just, in fact, there aren't very good versions of this sort of idea where you can draw a sort of parallel between the sex case and...
Yeah, thanks very much for that. In fact, a leading supporter of legalization, Gene Davis, now no longer with us, ran that argument in the Journal of Medical Ethics and said, well, look, you can't just have sex with someone without their consent. That's rape, You need consent in order to justify intercourse. But I think the weakness of the argument is that the argument for euthanasia is, I'm benefiting you by ending your suffering. My duty as your doctor is to benefit you. And I do that whether you're competent or incompetent. So if I see my patient suffering and they ask for, doctor, I'm suffering. Oh, God, I'll give you morphine. Okay? Yeah, give me morphine. Well, if I've got a suffering patient, I'm conferring the same benefit by giving them morphine even though they can't consent to it. So I think given that if euthanasia can be a benefit for the first patient, it's also a benefit for the second patient. And that's how doctors operate. They say, well, if I think this is benefiting you, it will benefit this other patient who is in the same situation as you, but can't ask for it. So in my book, I have a little analogy where I've got, these two twins are in exactly the same position, exactly the same suffering, and A asks for a lethal injection and then says, oh, and give one to my brother B because he can't ask for it. Why is the doctor to stay his or her hand? Surely the doctor must say, yes, I know relieving you of suffering is a benefit, but I'm not going to relieve your twin brother because why? So I think the argument of the analogy with intercourse falls down because you're benefiting the patient by ending their suffering. You're conferring a benefit, and you don't need to consent to confer benefits on your patients. In fact, it's your duty to confer those benefits. A number of cases, judges have said, not only may doctors give palliative care, even if it shortens life, it's their duty to do it. And the Dutch judges perfectly consistently saw that, said, just as we ruled in 1984, that the doctor's benefiting the patient by killing them, by ending their suffering when they ask for it. So now, well, it's the same with these infants. They can't ask for it, but they are still suffering. And therefore, we are holding that the law applies to them as well.
Ask you about the change to British law that resulted in eliminating suicide as a crime in the first place. In particular, you quoted someone that's saying at one point, well, in this case of self-murder, we're treating the person. We want to treat the person in such a way as not to punish them. But it struck me that to talk about murder in any way, shape, or form, and that the legal response to murder, whether of oneself or another, is treatment, has already given away a lot of the game. So I wonder if you would comment on the legal preparation for euthanasia in the decriminalization of suicide.
Well, yeah, there is that danger, and that's exactly what has come to pass. That even when you have these very eminent former senior judges, including the former president of the Supreme Court, they failed to see that the decriminalization of suicide was not a condonation of suicide. So there's a risk in practice that people will forget why it was decriminalized. But the initial reasoning was that people, we now realize with the advent of psychiatry and our understanding that the suicidal are often seriously mentally ill, and that's why they're jumping under bridges and throwing themselves under trains, that the best way of preventing that is not through arresting them and locking them up. It's through trying to help them, guide them, steer them towards mental health services. So I don't think there's any contradiction or objection. I think that was actually an enlightened development. But there is a risk, and it's materialized, that people forget the rationale of decriminalization, and fall into the trap of thinking it was condonation.
The terms of description are contradictory. On the one hand, you still use the language of self-murder, and then so with non-self-murder, that is to say, homicide of another person. We don't in the law speak about treating the homicidal killer, right? There's a punishment for the killer.
Well, yeah, I think they recognize that the victim is actually not somebody else, so you're not harming anybody else, you're harming yourself. And if you want to try and prevent that from happening, and the criminal process is actually counterproductive or useless, then, as it were, trying to help and treat rather than arrest and prosecute, which is hopeless anyway when they've succeeded in killing themselves, is an enlightened social response, it seems to me. I don't think one's giving anything.
It's found not guilty by reason of insanity of a murder or an attempted murder. We don't say about that person, they didn't commit a crime because they were insane. We say rather that what they did was criminal, but their insanity rendered them incapable of sound judgment about what they were doing.
Mm-hmm.
Now, you might argue analogously with punishment with suicide, but you wouldn't. If you were really being arguing analogously, you wouldn't talk about treatment. In other words, the decriminalization, as you described it, and I don't know whether it was in the law, actually does seem to me to already undermine the seriousness.
Well, you're decriminalizing it, you're not saying it's lawful, and I think that's another important distinction. Suicide remains unlawful, as Lord Bingham said, contrary to the policy of the law. So there are other ways in which you would be acting unlawfully if you tried to, well, certainly it's a crime to help someone, but it's regarded as unlawful as well. So, for example, in relation to insurance policies, the law might say, well, you can't claim on that because it was unlawful. There are all sorts of unlawful acts that are not criminal acts. So the law's not saying it's right, it's good, it's saying it remains wrong in the eyes of the law, but we're just removing the categorization of criminal punishment from it. But we still want to discourage it, and that's why we're decriminalizing it, to discourage it, not to encourage it.
Time for one more question.
only if it's an easy one.
Yeah, I'll just make a comment. I think on the causation, one difference would be if the cause of death, if ventilator is withdrawn, or I think very importantly, something is not started. You know, a treatment is not just withdrawing, but withholding a treatment. Would that properly characterize the cause of death? And I think on a death certificate, that wouldn't, you know, the withdrawal would not be listed as the cause of death. So that's consideration. But that leads to a comment about the laws, including Oregon, the California law, all the ones that have been passed in the United States, is that the suicide, which of course is now aid in dying, or, you know, they've taken that phrase, the laws specifically state this shall not be counted as suicide, and it shall not be recorded as suicide, and in fact, the cause of death cannot be listed as suicide, but whatever the underlying, you know, pathology is, that supposedly would have led to death within 6 months. So, you know, there is a whole enterprise here to deny that this is actually suicide, and I think that's a really important. I don't know if that was in the British law or not, but it's in virtually all of the American laws, and I think is, you know, worth, you know, in terms of the flaws and everything, I think is worth an additional comment.
Yeah, it's an exercise in obfuscation, isn't it, really? It's like you see these doctors in Belgium and the Netherlands who will say, when they've just given someone a lethal injection or a lethal concoction to drink and the person takes it, will say, no, it's a natural death. I mean, it's just a denial of reality, really. And of course, there's so much of that engaged in the debate. We have the very phrase assisted dying, which is obfuscation, deliberate obfuscation, seems to me, to try and pretend that this is a totally natural process that we're assisting, instead of intentionally hastening death. So we have to be very careful about our terminology. But I just think, yes, in reality, we wouldn't say switching off a ventilator, that's not listed as a cause of death. But I think morally, and in reality, it's difficult to argue why it's not. Especially if someone's been on a ventilator for a while and could go on living for a long time, and you decide to turn it off, to say you have not caused that patient's death, I find unconvincing. Okay?
Now we have a reception.